Justice Alito? Justice Sotomayor?
I paused when I was reading the briefs in this case. Is the intrastate preemption subject to challenge? Because if it's been decoupled from interstate commerce, under what congressional power could the government preempt?
I'm guessing. I mean, it's probably a pretty good question for the federal government. If I had to make the argument for them, I would say that it's under the necessary and proper clause, and it would be under the theory that they needed to regulate the intrastate in order to rationally deregulate the interstate. But I guess I'll take the question as a friendly amendment as just one more reason to leave the intrastate provision for a case where it's actually at issue. Because the one thing that's crystal clear here is they have no B argument. This is interstate. And so,
yes, and I do understand what you're saying to Justice Kavanaugh and Alito, which is the difference between intrastate and interstate is even wider than whether you cover brokers or not. Because intrastate, they're preempting everything, not just whether it's in transport of property.
right. And, you know, like if I were going to warm to the topic of having to have a theory of how all this works, I suppose if what they were really trying to do in 1995 is make sure that the state regulation sort of doesn't interfere, maybe they just address it a little bit differently.
Could I stop you to go back on the shipper question? Because one of my questions in my mind was, how far back can you go? Could you go to the shipper? And you're saying in many states you can. Would that be for hiring a negligent carrier or for hiring a negligent driver?
So
is the liability automatic for the shipper?
So under certain circumstances, and I think the most circumstances, it would be for hiring a negligent carrier. But I think it also could get to the driver level. I mean, I think, you know, in a case like this, like, you know, and this happens more frequently than you think. I mean, I think one of the other statistics in the amicus brief is some 50% of all carriers only have one driver. So particularly if you're a broker, you may very well know not just what carrier you're getting, but what driver you're getting.
But your point is that the shipper would not be preempted under any circumstance. So this lawsuit doesn't have a defense under this Act if you're suing the shipper.
If you're suing the shipper, that's right. Now, there is an amicus brief here that's, you know, or two actually, I think, on behalf of shippers that are making what I think is kind of an extravagant argument that they are covered by the preemption provision, even though it obviously doesn't address shippers and it only addresses carriers, brokers, and freight.
Do you happen to know if there are lawsuits against shippers that go on routinely?
My understanding is that there are, but my understanding is that, you know, it's also caused some shippers to start using brokers because
it's a way to
at least
try
it gives
to
you a colorable textual preemption argument to use a broker.
Thank you.